This is Jeffrey Davis, and I'm the host of Radio Entrepreneurs, and welcome back to the show. And we are always sharing the success of entrepreneurship, and I'm glad to say, for those who are watching online or in our YouTube video, we are in our new Radio Entrepreneur Studios, and quite spacious and comfortable. I hope our guest thinks so as well. And our next guest, a big supporter of entrepreneurship, is Patrick Waller of Wolf, Greenfield, and Sachs. Hi, Patrick.
Great. Hi, Jeffrey. Thanks for very much for having me today.
Great.
So I'm going to tell you a little bit about what we do and some recent developments in patent law, which are impacting a lot of companies. So I work at Wolf Greenfield, which is an intellectual property law firm, and we specialize in all aspects of intellectual property. I'm in the biotechnology practice, where we have, I think, the largest group of intellectual property attorneys in the New England area, if not in the country, and under a single office, working on all aspects of healthcare, pharmaceutical, medical devices, with respect to patents. But there have been a number of cases over the past few years that have really expanded on that concept, and to some extent raised a lot of interesting questions, which are interesting academically, but are big issues for clients and for companies who work in this space. And so, for example, if you take, particularly in the healthcare and the biotechnology space, if you take for example, a natural correlation between a genetic marker and a disease, or maybe a natural response of a biological product, or natural response of a patient to a biological product, for example, in a therapeutic context, for example, response to insulin or adrenaline, those are natural responses. They're not, it's not magic. They are based on natural processes. But there's been case law, and the Patent Office has, to some extent, expanded on where the case law ended up, and expanded some of their guidelines to cover all of these types of natural processes, and are now going to be examining patents with much greater stringency for claims that relate to anything natural, which means that if you're trying to get a claim to a method of treating a disease by administering a drug that maybe is a natural product, there's going to be much greater scrutiny given by the Patent Office. And it means those claims are going to maybe much more difficult to get issued, and they may be narrowed much in significant ways that could have commercial impacts on companies. So this is a very, very big issue for companies. And the guidelines came out in March this year, and so we'll still have to see how they play out and how the Patent Office implements them. But many companies are concerned about whether their patent rights are going to be significantly narrowed in this space.